through the legal duty to report that we're actually assisting those victims who is finding it difficult to have their own voice. We all know what the headlines are looking like. On any given day, you would find a lot of headlines that refers to gender-based violence and the impact that it's having on our society, from the murders to pregnancies with pupils. And we know that sad truth that in South Africa, we have amongst the highest levels of intimate partner violence in the world, with reportedly 51% of women experiencing violence in a relationship. I think most of us attending this webinar are well aware of the cycle of violence and how that is also impacting on reporting, as well as other related factors, in particular social and other economic aspects. We also know that there are other reasons why it is so difficult for victims to report. They most likely have been told that they will not be believed. And abuse over a period also resulting in very low self-esteem and self-confidence, and making it extremely difficult for them to seek help, talk about it. And how often do we all not know friends, family, colleagues that we realize is most likely in, for example, an abusive relationship? We know that there are a variety of reasons why this friend, family member, colleague won't report and being too afraid to report. And the question is essentially, for all of us, what did we do? What are we doing to assist her? Have we reported? Over the past few years, there had been quite a lot of newspaper reports regarding the teen pregnancy crisis in schools. And that resulted towards the end of last year in the Basic Education Minister gazetting a policy on the prevention and management of teenage pregnancies at school, which includes reporting such matters to the police. The question, however, which we will talk about later, is whether or not it really was a question of the department needing a policy, or rather that educators needed to understand that there is a legal duty that to report in certain instances, which we'll look into more detail. I thought it important that we just stand still for a second at the Constitution, and in particular the constitutional rights and the Bill of Rights. We always hear about the right to equality, but we sometimes forget about the fact that the right to equality also include, in particular, the right of each one of us to have equal benefit and protection of the law. And in certain circumstances, because our right to equality is a right to substantive equality, it is important that, be that protective measures or other measures, be necessary in order to assist people to actually get equal benefit and protection of the law. We all know about the right to dignity, the right to life, and the right to freedom and security of a person, which includes the right to be free from all forms of violence, be that from a public or a private source, to bodily and psychological integrity, security, and control over your own body. There's, for example, the right against slavery, servitude, and forced labor, the right to privacy, the right to freedom of religion, belief, and opinion, the right of freedom to expression, and of course, we all know about Section 28 dealing with the rights of children, where the best interest of the child always need to be paramount. Why am I referring to all of these rights? When we are dealing with gender-based violence, essentially, in most instances, there would be a violation and an infringement on one or more of these rights of the persons that are the victims of gender-based violence. And the question is how we can assist and what we are legally obliged to do in order to ensure that the infringement of their basic rights can stop. As a country, we are signatories to the African Charter on Human and People's Rights. One of the important things about the African Charter on Human and People's Rights that is different from some of the other regional and international instruments on human rights is that in the African Charter, it specifically makes provision not only on the rights that all people have, but also the responsibilities that we all have. And particularly in Article 27, 28, and 29, that we all have duties towards families and society. And each one of us must exercise our rights and freedoms with due regard to those that of others. We also have a duty to respect and consider our fellow beings and to maintain relations. And we also have duties to preserve the harmonious development of the family and to work towards for the cohesion and respect of the family. We all know the well-known reference to Ubuntu. We are a person through other persons, and the importance of understanding that we cannot each be an island on our own, and that we do have responsibilities towards our fellow human beings. There's a variety of different definitions of gender-based violence. In context of what we're talking about here, I thought it would be of use to refer to a very broad definition of gender-based violence, that being a general term used to capture violence that occurs as a result of the normative role expectations associated with each gender, along with the unequal power relationships between genders within the context of a specific society. We know that there's a lot of different dynamics that play a role when we are talking about gender-based violence and reasons, for example, for not reporting. Oh, apologies. In 2018, in the Liebenstein case in the Constitutional Court, the Constitutional Court referred to the fact that the systemic sexual exploitation of women and children depends on secrecy, fear, and shame. Too often, survivors are stifled by fear of their abusers and the possible responses from their communities if they disclose that they had been sexually assaulted. And this is also exacerbated by the fact that the sexual perpetrator is in a position of authority and power over them. They are threatened and shamed into silence. These characteristics of sexual violence often make it feel and seems impossible for victims to report what had happened to friends and loved ones, let alone state officials. Combined with this is the frequent impact of deeply located self-blame, which disables the victim from appreciating that a crime has been committed against her for which the perpetrator and not she is responsible. Too often, unfortunately, we hear again and again, and see in the courts as well, how people that have known, realized what is going on, prefer to turn the blind eye, not to get involved, to walk away from when people are needing assistance, for when they are in a position, and sometimes through a simple phone call, to make a difference and to help stop violence against the victims. What a lot of people do not realize is that in terms of the law, in different pieces of legislation, there had been and currently still is legal obligations on us to report some of the gender-based violence that we are aware of. And in fact, if you were aware of it and you did not report it, you are actually committing a criminal offense. In the Criminal Law Sexual Offences and Related Matters Amendment Act, Act 32 of 2007, the current provision, which will actually now be deleted and substituted, and we'll talk about the new wording, which is much wider. But as well, the current provision, as it will be for the next week or so still, is that in Section 45, an obligation to report the commission of a sexual offense against children or persons who are mentally disabled had been part of our law ever since the Sexual Offences and Related Matters Amendment Act came in operation in 2007. That a person who has knowledge that a sexual offense has been committed against a child must report such knowledge immediately to a police official. And a failure to report is an offense. Coming back to the teenage pregnancies, or the school learners being pregnant, clearly there is a duty to report, in particular where you have learners that is under the age of 16 and pregnant. Section 54 also have the obligation to report the commission of sexual offences against those that are persons who are mentally disabled. In this regard, it's not just about a person who has knowledge, but also a person that have got a reasonable belief or suspicion that a sexual offense has been committed against a person who is mentally disabled. They must report such knowledge, reasonable belief, or suspicion immediately to a police official. And again, failure to report it is an offense. Section 54, as most provisions in this regard, specifically provides that a person who in good faith reports will not be liable to any civil or criminal proceedings by reason of making such a report. Once the amendments came in operation, Section 54 will, however, change. And the scope of the duty to report is being extended. Once operational, it will provide that a person who has knowledge, reasonable belief, or suspicion that a sexual offense has been committed against a person who is vulnerable, as defined in Section 40, and we'll look at that just now, must report such knowledge, reasonable belief, or suspicion immediately to a police official. Failure to report makes you guilty of an offense. It still have the provision that if you report in good faith, you will not be liable for any civil or criminal proceedings by reason of making such report. Once the reporting is done, obviously, the police will do the further investigation, and they will investigate to see whether or not the criminal offense had been committed and so forth. It is not for the person who reports to do any investigation. They just need to give the information that they are aware of to the police in order to set the wheels of justice in motion. Who is a person who is vulnerable? Now, there would be a new definition in Section 40 of the Sexual Offences and Related Matters Amendment Act. Once these amendments comes in operation, a person who is vulnerable includes a child or a person with a mental disability, but it will also now include a female under the age of 25 who received tuition at a higher education college, institution, or university college, receive vocational training at any training institute, other than the ones referred to already, or who lives in a building, structure, or facility used primarily as a residence, basically for students. It also includes a person who is being cared for or sheltered in a facility that provides services to victims of crime. A person who's vulnerable further includes a person with a physical, intellectual, or sensory disability who receives community-based care and support services other than from a family member, or lives in a building, structure, or facility that's primarily used as a residence for them, or cared for in a facility providing 24-hour care to persons with such disabilities. And a person who is vulnerable further includes a person who is 60 years of age or older that receives community-based care and support services other than from a family member and lives in a building, structure, or facility used primarily as a residence, or is cared for in a facility providing 24-hour care to such persons. So it is extremely important that we all have a good understanding of who is regarded now in terms of the law as vulnerable persons, upon who we need to essentially, in terms of the law, look out for. And if we have knowledge or a reasonable belief or suspicion that there is sexual offences being committed against them, that we need to report such to the police. In the Film and Publications Act of 1996, Section 24B, that deals with the prohibition offences and penalties on the possession of films, games, and publications, have had for a long time, subsection 2, in terms of which any person who having knowledge of the commission of any offence under subsection 1, in other words, that a person is in possession of child pornography, or the preferred terminology is actually child sexual exploitation and abuse material, If you have knowledge of a person being in possession of such, or having reason to suspect, then you need to report the knowledge or suspicion as soon as possible to a police official and furnish to the police official all the relevant particulars that you have. Failure to do so, you are guilty of an offense as well. And this has been a crime for quite a long time. The same with regard to the provision in the Children's Act 38 of 2005 in terms of section 110, where there's a duty on specific categories of persons to report abuse or neglected child and child in need of care and protection. If you're a correctional official, dentist, homeopath, immigration official, labor inspector, legal practitioner, medical practitioner, midwife, a minister of religion, a nurse, occupational therapist, physiotherapist, psychologist, a religious leader, social service professional, a social worker, a speech therapist, a teacher, a traditional health practitioner, traditional leader, or a member of staff or volunteer worker at a partial care facility, drop-in center or child and youth care center, and you've got reasonable ground to conclude that the child has been abused in a manner causing physical injury, sexually abused, or deliberately neglected, then you must report it. Now, for these professionals, there is a prescribed form in terms of which you can then do your reporting to either a designated child protection organization, the Provincial Department of Social Development, or a police official, who then must investigate and take the matter further. But it's not only a duty on these professionals, it is also any person who on reasonable grounds believes that a child is in need of care and protection. They may report that belief to the Provincial Department of Social Development, a designated child protection organization, or a police official. If you do these reportings, you need to substantiate that conclusion or belief to the body you're reporting it to. Obviously, to ensure that you give them the relevant details so that they can follow up on it. And as long as you make the report in good faith, you would not be liable for civil action on the basis of the report. If you look in section 305 under offences, you would notice that failure to comply specifically with section 110(1), that is in regard to the list of professionals. If they fail to report, remember that was a mandatory report that needs to be done, then it is actually, then you are committing a crime. Coming back to the Constitutional Court, it was stated by the Constitutional Court in State versus Paloi that all crime has harsh effects on society. What distinguishes domestic violence is its hidden, repetitive character and its immeasurable ripple effects on our society and in particular on family life. It cuts across class, race, culture, and geography, and is all the more pernicious because it is so often concealed and so frequently goes unpunished. We recently were talking also about the fact that where there is, for example, domestic violence in a household, even if the children are not directly abused, they are indirectly abused as well. And the impact of what is going on in the household can have a long-term effect on all these other members of a family that are aware of what is going on and standing back, not wanting to interfere and allowing it to continue. Because of this hidden nature of domestic violence, in the Domestic Violence Amendment Act, the obligation to report has now been included in the Domestic Violence Act specifically as well. Now, note it's not yet enacted, but as soon as it is enacted, this obligation will be on the relevant functionaries as referred to in the section 2(a) that is now being inserted in the Domestic Violence Act through the Domestic Violence Amendment Act, in terms of which the minister may by notice in the Gazette designate any other person belonging to a class or categories of person or who's in employ of any class or categories of entities as a functionary. In the definition section in the Domestic Violence Act, there will also be a definition of functionary included, which reads that a functionary means a medical practitioner, healthcare personnel, a social worker, an official in the employ of a public health establishment, an educator or a caregiver, as well as any other person designated in terms of the section 2(a)(1), and that would be the designation by the minister. So what does that mean for this list of functionaries that is in the definition and also those that may be designated by the minister? Section 2(a) provides that a functionary who in the course of the performance of their duties and the exercise of their function obtain information which after evaluation by them causes them to believe or suspect on reasonable grounds that a child, a person with a disability, or an older person may be a complainant as contemplated in Section 1, that would now be of the Domestic Violence Act, and must without delay complete a report in the prescribed form setting out the reasons for such belief or suspicion, and in the prescribed form, this would now be in the regulations, submit this report to a social worker or a member of the South African Police Service. They must conduct a risk assessment as contemplated in Section 18(b), which will also be inserted in the Domestic Violence Act, and they may, after the evaluation of the risk assessment, provide or refer the complainant for further services as contemplated in Section 18(b). Section 2(a) also provides that a functionary who makes the report in good faith will not be liable to civil, criminal, or disciplinary action on the basis of the report, despite any other law, policy, or code of conduct prohibiting the disclosure of personal information. They are also entitled to have their identity kept confidential, unless the interest of justice require otherwise. But the duty to report is not only on the functionaries referred to here. The further provision that has been included to deal with the duty to report commissions of acts of domestic violence is anybody, any person who has knowledge or a reasonable belief or suspicion that an act of domestic violence has been committed against a child, a person with a disability, or an elderly person must report such knowledge, reasonable belief, or suspicion immediately to a social worker or a police official. Now, please note, if you look at the categories of people that we are talking about here, child, person with a disability, and an elderly person, you would see that this lines up to an extent to the people that is being regarded as vulnerable persons, also in terms of other legislation. Again, if you are failing to report your knowledge, your reasonable belief, or your suspicion, you are guilty of an offense. And even in common law, there had been a duty to report in certain circumstances. And that failure to report, the failure to do anything, to speak up, had been acknowledged to be a crime. Section 2, capital B. Let me just, sorry. 2, capital B in 1, in regards to this particular vulnerable groups, provides that when you have knowledge, reasonable belief, or suspicion that you need to report. 2, capital B, 2A, with regards to other victims, if you have knowledge, then you must report that knowledge immediately to a social worker or a police official. And again, failure to report makes you guilty of an offense. But note the difference just as far as other adults are concerned, it is about knowledge. Then you have the duty to report. However, where it's a child, a person with a disability, or an elderly person, if you have knowledge, a reasonable belief, or a suspicion, then you must report that as well to a social worker or police official. Coming back to what I was talking about in the beginning, that we need to remind ourselves of our basic rights in terms of the Constitution, starting off with the right to equality. And it is of importance to note that in the Promotion of Equality and Prevention of Unfair Discrimination Act, there is the general prohibition that not the state nor any person may unfairly discriminate against other persons. And we need to look at the prohibited grounds. One of the prohibited grounds in particular is on the ground of gender. And Section 8 of the Promotion of Equality and Prevention of Unfair Discrimination Act specifically makes provision that no person may unfairly discriminate against any person on the ground of gender, including gender-based violence. It is important for all of us to remember that gender-based violence is a form of unfair discrimination. Under unfair discrimination on the grounds of gender, it also includes any practice, including traditional, customary, or religious practice, which impairs the dignity of women and undermines equality between women and men, including the undermining of the dignity and well-being of a girl child. I want to refer back to the Constitutional Court. In a Minister of Home Affairs versus Fourie matter, the Constitutional Court was talking about the fact that a democratic, universalistic, caring, and aspirationally egalitarian society embraces everyone and accepts people for who they are. To penalize people for being who and what they are is profoundly disrespectful of the human personality and violatory of equality. Equality means equal concern and respect across differences. It does not presuppose the elimination or suppression of difference. Respect for human rights requires the affirmation of self, not the denial of self. Equality, therefore, does not imply a leveling or homogenization of behavior or extolling one form as supreme and another as inferior, but an acknowledgement, an acceptance of difference. At the very least, it affirms that difference should not be the basis for exclusion, marginalization, and stigma. At best, it celebrates the vitality that difference brings to any society. In particular for me, from this quote, is the fact that it was stated that equality means equal concern and respect. Going back to what is stated in the African Charter, we all have human rights, but we also have duties. And part of our duty relate to having equal concern and respect for our fellow human beings, and that we need to be assisting each other. I thought it important that we just remind ourselves generally also of the fact that there's a service charter for victims of crimes in South Africa, in terms of which it has as its objectives the fact that we need to eliminate secondary victimization in the criminal justice process, ensure that victims remain central to the criminal justice process, clarify the service standards that can be expected by and are to be accorded to victims whenever they come into contact with the criminal justice system, and to make provision for victims' recourse when standards are not met. As a victim have got the right to be treated with fairness and with respect for their dignity and privacy, the right to offer information, to receive information, the right to protection, the right to assistance, the right to compensation, and the right to restitution. We will have a webinar on the 27th dealing in detail with the National Register for sex offenders. But I just want to remind everybody that there's also duties on employers. In respect of all three main registers when we are dealing with gender-based violence, and that would be the Register for Sex Offenders, the Child Protection Register, as well as the Register for the Protection of Older Persons. And that whenever it is any institution, organization, etc., where any of the vulnerable groups would be working at, staying at, going to school at, there's a duty on the employers to get the relevant clearance certification that such a prospective employee does not have any convictions in terms of which they are included in any one of these registers. If you look at the definition of employee, in most instances in the different legislation, it does include volunteers as well. So it's not just employees here that necessarily are being paid. And it is an important duty on an employer as well. Obviously, on anybody applying for a position in any one of these kind of institutions and or to get a license, etc., to run such an childcare institution, for example, they also have the duty to disclose whether or not if they are on the register, and failure to do so is actually an offence by itself as well. There recently had been in the Constitutional Court a case about the failure of the Department of Education to get a certificate in regards to a teacher that was employed, which they later turned out whose name was actually in the National Register of sex offenders. Yet subsequently, whilst at the school, sexually assault learners again. And in the end, there was a civil case suing for damages due to their failure to ensure that they clear prospective employees. So it is also important to realize, and that's not the only case of a civil case of that nature where damages had to be paid for the failure to comply with legal obligations, the failure to report or to ensure that a matter is dealt with. There is no more sweeping under the carpet. We cannot allow that any longer. The sad part of it all is that a lot of these obligations to report has been in the legislation. It's just not being taken seriously by anybody. And we really need to change that as well. As one of the ads that was going around say, turn down your radio, don't drown out the sounds of gender-based violence. Listen and act. And act here is the duty to report when we have knowledge and in certain instances, reasonable grounds or a suspicion, in particular when we are dealing with the most vulnerable of people that are put in a situation where they cannot speak for themselves. Thank you, and I would appreciate some discussion on this. Handing back to you, John.
Thanks, Yaki. I saw that there are, sorry, I'm just still admitting people. There are a question, but there's also a request for a lot of people to get the presentation. And Karen Holloway says, morning, she was requested by a family member who received the first disclosure by a child victim of intrafamilial sexual abuse to navigate the reporting process. Said family member went to the police station to report. And then she says that there was alleged evidence of the abuse on the victim's cell phone. As mentioned, the first disclosure was made to this person. However, the police refused to open a case and argued that the family's member's report was hearsay. And then again, she emphasizes the lack of training of the police and social workers. So I don't know if you have experienced something similar, or if you have any comments.
Unfortunately, we all know, having worked in the field for a long time, that sadly is what happens a lot. And I think that is where the initiative with having the one-stop centers, our Tutuzela care centers in particular, where it's also prosecution driven, but all of the relevant stakeholders are working together, why they are playing such a big role or an important role. And we need to make sure that the matter should not stop there. If they need to take it further, report further, it really needs to happen. there will be a webinar next week on the 4th on the extension of services of the Tutuzela Care Centers. But you can actually report a matter there instead of going to the police station as well. So unfortunately, there's currently only 60 Tutuzela Care Centers, but they are expanding. But like I said, there will be a webinar on their extended services. But we really need to make sure that police stations or officials that do not take these matters seriously, as they should, that they need to be reporting further. I see Gregory's hand is up, and I'm pretty sure, Gregory, that you wanted to say something about this as well. So please, Gregory, go ahead.
Yeah, Jackie, I think you know me by now. You are the better half of myself. You and Praise. That's right. Jackie, I think a couple of things that what's in my mind here is three issues. One, it means that we have to sit down as a team with the police in terms of saying that when they amend the national instruction, this clause must be put into that as well. There. The second thing which brings to my mind now is that it simply means that the acts that govern the iPad must be amended in order that pit of matters must be looking to this matter, how we deal with the matter as well. Now it comes down to the issue of reality. How do you put a measurement tool together to see to it that this will happen in a practical side in the police, which is the biggest culprit on their frontline services? Two, then the question of forensics as well, if it's not being reported, how will it be applicable of pit of measures taken at a police officer on a crime scene into the national instruction? So it means that a number of national instructions at the same time will have to be rewritten in order to accommodate then this amendment and also look in the basis that how can we empower further than that as well that other magistrates who may not be taking the basis, working away from crime scenes and looking at the basis that they are not doing what they're supposed to be doing in a bit of way as well.
Thank you, Gregory. I think you probably have something to add, Yaki.
Yeah, and I'm pretty sure you've got something to add too, John. I mentioned the fact that with regards to something like the school learners' pregnancies, that, and the reports are that there were school learners, children as young as 10 years old that was pregnant there in the schools. And I personally had done cases where a 12-year-old would be pregnant and nobody would ask a question, raise a concern, anything. And I mean, I remember that witness was a tiny girl. How nobody could, you can't tell me that nobody realized that she was pregnant, for example. In any event, to come back to this, regardless of the fact that there's been this legal obligation in the Act all along, it needed the Department of Education to have a policy in place to make it mandatory for them to report. It shouldn't actually have been necessary, but I suppose it comes back to what Gregory was also saying, that how important it is for all of the relevant institutions, functionaries, etc., to know what the obligations are, but also that within that workplace and situation, that it be taken seriously and be done and dealt with. And we really need to make sure that the functionaries to whom the reports can be made between the different acts, for example, the police and or social workers, that they have to understand that they must follow it up. They cannot ignore these reports. Thank you, John.
Thanks,
You can
Yaki.
add your voice too.
Yeah. I think what I want to say is going in a bit of a different direction. So I'll first give Tsepo an opportunity. Go ahead, Tsepo.
Hello?
Yeah, we can hear you. You can go ahead with your comment.
Okay. It's my colleague here who wants to ask a question.
Okay, hi. I have a question here because I heard you guys talking about the people that are vulnerable, because you sometimes come across a person who has been a victim of domestic violence, and then you find out that he or she can't go back home because it's not safe for him or her. So I heard you guys saying that you can take the person and put them in a place of safety or care centers, or as if there's a minor that needs to be taken away from that place. But the problem is we are in the rural areas and we don't have such places here. We don't have place of safety. We don't have care centers. We don't even have a children's home. So how are we going to be assisted, and have the social worker been told about these whole things, and the police officers who must assist us as well? Thank you.
Thank you, Tsepo. Yaki, I don't know if you have something to add. I have a couple of comments.
Yeah, I'm in a rural province too. I understand what Sepu is talking about and the problems, the difficulties in this regard. But it doesn't mean that we should not strive to ensure that we make a plan to deal with the situation in these instances as well. Which comes back to the need for all of us to start working together and to start looking at how best we can assist the vulnerable persons, and as a community also assist. But John, you go ahead. I see there's a couple of other hands as well.
Yeah, thanks. So I mean, the question of what happens in places where people don't have access or easy access to a service like the TCC has obviously been highlighted quite often over the past couple of years, especially because of the way that the police sometimes don't take the statements in a sensitive manner, or like in Karen's example, maybe don't even want to open a case. That's definitely the experience that we have at Rape Crisis. And if we say to people, you can report at a TCC, then that immediately brings up the question, but what if I don't have access to a TCC? And I think that's what Tsepo was also referring to. And the idea that that the Pillar 3 working group is looking at, and the NPA, is how do we deliver or better coordinate services so that they can be delivered in a way similar to a TCC, but without the cost of a TCC. And how can that also help people to report, for instance, at health facilities, and then receive services in a coordinated manner? So I do think there are ways, but I think we don't currently yet speak the language of delivering those services in a way that is cost effective, but that brings together the different role players so that survivors in more rural communities have access to a similar set of services. And yeah, I don't know if you want to add something to that.
Now, we're all in agreement with the fact that we need to start looking at how we can extend and consolidate services, in particular to the areas, the more rural areas, etc. But I know that the MPA does have some plans, etc. So again, it would probably be of importance for the people talking about this and or wanting to see what they can do, how that we can talk about this more when we have the webinar on the TCCs and the extension of services. But that should not excuse the fact that service or specific functionaries that need to fulfill specific obligations in terms of their job descriptions, in terms of the law, etc., that they don't do what they need to do. You know, we can't excuse the police officials that doesn't want, you know, that's chasing people away, or social workers that might not want to accept reports. We cannot excuse that. I see there's some hands still. Let's hear others on this conversation.
Francesca's hand is up. And then there's also a comment in the chat about the age of consent. But Francesca, you can go ahead first.
Thank you so much, Jean. Yaki, you know, when we look at general society and how this kind of behavior has been normalized, sometimes through customary practices, the general attitudes, macho attitudes, and the conscription of society in what challenges us. My concern is we amend the amendments. It's all these amendments to these acts, and they are long overdue. But I want to throw an idea out there. We've seen it with HIV/AIDS, and we've seen it also even in a local SOPI when at the start of the GBV discussion. When local script writers incorporate these amendments factually and correctly into these programs that people so glued to, isn't that a way that we can encourage scriptwriters to incorporate these amendments in a correct manner, portray it in a correct manner in these programs, so that the general population gets greater awareness? Because let me tell you something, sometimes you can tell people many things, but it somehow does not resonate. But when they see it in their favorite soapy or in some other story, somehow they absorb it better. Is it not a probability to create maybe a competition where an episode portrays something and there's a acknowledgement for the person who writes the best episode that brings a certain amendment, you know, really to the fore? You know, we laugh at these things, but with my experience, I find it sometimes in our government and, you know, strata, we find males resistant to what we are talking about right now. And if you have somebody saying to you, but what if a woman is happy with her customs, but that woman has never had an idea that, you know, she actually had rights, then I wonder if we should look at broadening our scope to bring these changes to the attention of people. That's my comment. Thank you.
Thank you, Francesca.
Yeah.
That's definitely an interesting idea, and I think perhaps something that the communications pillar of the NSP collaborative should definitely think about. And I want to just read Lebo's comment with regards to the age of consent. I wish we would stop calling statutory rape that leads to pregnancy. As teen pregnancy by law, one can only consent to sex at the age of 16. This also highlights the issue of what law is, and by laws, if you can only consent to 16, but you can get a termination of pregnancy at 12 without a parent, Why are these cases not being reported? So Yaki, maybe you can just clarify the issue of consent. When is it the age of 12 and when is it the age of 16? And the impact of the teddy bear clinic case. Yeah, I think that is probably content for a whole different webinar, right?
Yeah.
So yeah,
Well,
you can go ahead.
well, John, you can also go ahead because
okay, sure.
yeah.
So
Please do.
sure. So the age of consent for sex is the same as the age for consent to medical procedures, which is the age of 12. However, the law recognizes that there can be very difficult power relations between people who have a great age gap. So the law says for people between the age of 12 and 16, we are adapting the rules a bit, right? So if you are between the age of 12 and 16, you can have consensual sex with someone who is no more than 2 years older than you, right? Yaki, you have to jump in. I'm paraphrasing the act as I sit here. So that means that if you are 12 years old and you had consensual sex with someone who is 13 years old, right? Then you can obviously ask for a termination of pregnancy, and it wouldn't be statutory rape because of the age difference. However, if you are 13 years of age and you had sex with someone who is 20 years old, right? You were not able to consent to that, and that would mean that it would be statutory rape. So the age of getting a termination of pregnancy procedure is not is 12 because that is the age that you can consent to medical procedures. However, if we have child mothers of the age of 11, right, there's no way in which someone aged 10 or 11 can consent to sex, no matter what the age of the other party is, and that would always, therefore, be statutory rape. I don't know if that answers your question, and you're welcome to add, Yaki.
Thank you, John. Yeah, and it can be quite a complicated situation because if you take your example of the 13-year-old with the 20-year-old boyfriend or 25-year-old boyfriend, the issue as to whether or not the consent that is being given is actually consent through consent without any kind of coercion or etc. is probably also questionable. So it is a problem, but somehow or the other, they need to be, I mean, regard have to be taken for the fact that teenagers may be experimenting, etc. And you don't want to have teenagers that's more or less the same age be sent to jail for when they are experimenting. But it is a difficult situation. Personally, I've never really liked the idea of the statutory rape because I do think that it does get misused as a tool for plea bargains or guilty pleas. And unfortunately, I've also seen over the years that they would sort of do the plea and whatever. And then if you get to the sentence part and you start getting, for example, victim impact statements, etc., then there's a totally different story emerging, which then have had at occasion some of my colleagues resulted that they had to enter a plea of not guilty, recuse themselves, and the trial had to go on. And in which instances of quite a number of these matters that I know of, and I'm talking here specifically where the perpetrators had been quite a bit older than the victim, then it turned out that they ended up being convicted of rape. So some of this, like I said, it's open to being abused also, and this kind of drivenness to finalize cases and get stats, and or trying to, that everybody is not really actually checking and making sure that accepting a plea, for example, on so-called statutory rape, that actually is really what is the position. It is concerning, to be very honest with you. I've seen some cases that was really concerning in the way that this has been dealt with. But John, back to you. I'm pretty sure you also have seen some of these matters that one have some serious concerns about.
Yeah, definitely. And I also see Delene's message about she agreed with Lebo, the narrative should change. The indicator for collecting data should also reflect this. Focus should not be on the pregnant teen so much, but on the perpetrator, who is often much older. And I want to ask a question which relates to the reporting of adult suspicion of domestic violence against adults. And there's been quite a push from the domestic violence sector that making it mandatory for anyone to report a suspicion of domestic violence against the adult has a negative impact on the sense of agency that adult, often women, have, and the reason why they might choose not to report. And still the legislature included this. And maybe you can just kind of share your thoughts on if you think that the civil society organizations who protested against this, I don't know, was right, or how do we now navigate situations where adult women choose or don't want to report for specific reasons, but we as a public now have an obligation to report on their behalf? I think that can be quite a sticky situation, right? And I think that's something we need to be aware of.
I totally agree with you. I mean, it's not that simple and it's not that straightforward, and we all know and understand that. I think at least with the domestic violence, different to in Sexual Offences Act duty to report, where the duty to report is specifically to a police official, at least here the duty to report is to a social worker or a police official. And one can just try and hope, and also with reference to other services from the functionaries, is that I mean, the mere fact that if you report in particular to a social worker, it would not necessarily mean that there would be a case opened, etc. But hopefully it would at least mean that the victim would be able to get some support and assistance, even if they do not leave, etc. But, because it's a long road, I don't have to tell all of you working in the field about that. I understand why there was concerns about including this. And And I presume that's part of the reason why there's a reference to the fact that you're going to put to a social worker and not just only to the police, as it is, for example, with the sexual offences. I don't have a clear-cut answer for you. Sorry, John. I know it is a concern, but on the other hand, we also know how difficult it is for victims to get any kind of assistance. Not that this might necessarily make it better or easier, and it can create its other problems, but yeah, I don't know.
Jackie, can I perhaps come in there very quick that you raised something very important. I'm looking hypothetically in the same situation that I am Roman Catholic. I confirm my priest what I've done. The priest keeping between the will and God, but he serves the predicament of morality, how to report a matter, what implication of it as well. That I go to medical doctor, I do exactly the same. I said to my lawyer on a conscious and conscious issue, I raised it. That's what have happened. Deal with the matters around it. But at the end of the day, that is what I've told. I go to the next person, I'm going to do exactly the same. I'm going to confess again. Nothing is happening to me because of ethical and moral obligations. Now, when I look in regulations as well, that into medical doctors and health practitioners and social workers, it tells me that in terms of ethical oath, an amendment needs to be done in order to deal with this matter where conscience needs to be there. The question I'm asking that, how then do we start looking at the complexity of this matter in a way that we need to see to it that we need to make an enforcement act that compliance should be then the process of taking this person to justice.
Gregory, are you done?
I'm done, Jackie.
Yeah. Before I give Yaki an opportunity to comment, I see there's a couple of other hands as well. I do want to make one comment about the what did you call it, an implementation act, right? Which is it's this very I don't know, like we are always very tempted to when an act is not implemented correctly, right? We want to make another act to force people to implement the first act correctly, right? However, unfortunately, we would have very many duplicate laws if we were to do that. And that's unfortunately not the best way to ensure implementation. So, but I do think it really gives us something to think about when we write laws initially, right? Because a law really, I mean, you can really only hold someone who is responsible for implementing accountable if the law makes provision for that. So our primary legislation should really have the accountability mechanisms built in already, so that we don't have this feeling that we have to create new laws in order to enforce the primary ones. I don't know if you want to add something to that, Jackie.
No, but yeah, implementation is key. And we do know that we don't always have the best track record in regards to implementation. So we really need to start looking as to ensuring how we can, or as to why we have implementation problems, and to ensure that we can have this laws that is to the benefit of all, including the administration of justice, and that it be properly implemented. It shouldn't be that problematic.
Tsepo, I don't, is your hand still, is it a legacy hand or is it a new hand?
No, it's not up.
Oh, okay. Deline, your hand I see is up. Is it intentional or accidental?
It's entirely up to you, Jean. But I would like to just add 5 cents if I could.
Sure, go ahead.
Just in terms of your question that you posed, and it's something that was deliberated on quite extensively regarding the reporting of adults. And as you would see, the insertions in section 2A and 2B of the Amendment Act speak specifically to bystanderism, where people have just, they see that there's abuse and they just leave it. So in terms of both of these sections, it's not adults who are not deemed to be vulnerable. So it's only the category of where it is a child, someone under the age of 18, and it's a person with a disability, which is also defined in the Act, and then or an older person. So if an adult were to be a person with a disability or an older person, and they fell in this category, then there would be an obligation to report on both the functionaries and on another adult person who was aware. And as Yaki so rightly said, then that reporting would be to a social worker or to the police. So it's not for all adults. There is no reporting obligation on an adult outside of that category, because one needs to also respect their autonomy and their knowledge of what is safe for them and when they can act and when they can't, because one doesn't have a full picture in that regard. You could actually be placing them in a much more dangerous situation. Thank you.
Cool, thank you. Thanks for clarifying, Deline. I want to just check, Yaki, if we have the spot until 11:30 or until 12.
I think 11:30, isn't it? This was a shorter one.
Yeah, all right.
Yeah.
So I want to give a last opportunity for questions. I don't see any more questions in the chat. There is a note. Wait, here's a question. So Philip says he has a question regarding fathers that violate their children with the mother's inheritance, are promising them to take them to school with the money, but not doing it. Instead, they use the money with the stepmother, not taking the kid to school with the money. Philip, I'm going to ask you to just unmute your mic and give some context to the question, because I'm not sure if this question is about gender-based violence or about some other issue in the Children's Act that having to do with the child's best interest. Maybe you can just unmute and give us some, or if it's a theft issue, yeah, maybe just give us some clarity.
Hello?
Hi, yes, we can hear you.
Yeah. Yeah, even me myself, I'm not sure is actually the question is based on straightly to gender-based violence, but I think it's a good question to ask because it's based on the father, the child, the mother. So according to myself, I think it's a good idea to ask. Maybe I can get clarity from you guys.
Okay, I'm going to try and just check. So the mother passed away.
Yes, the mother passed
Okay.
away. The father actually went to marry the child because he knew it that the child gonna get the money from the mother. So when the child got to 18 years, so he promised the child that he's gonna take care of the child, take the child to school. But instead, he didn't do that. He took the money, then stayed with the child, but he's suffering the child. He's not doing a lot of things for the child. He's doing things for his family and his own child with the money of the child. The child right now is suffering from going to school because he doesn't have the money. the father took it away from her. So I wanted to know this kind of issue, you guys address them or is something else?
So can I jump in? So this sounds like something that is not strictly to do with gender-based violence, but rather with child abuse, right?
Oh,
Or a child protection issue. If it sounds like a parent have an obligation to look after the child, but refuses to do so and uses their means to support other children. So I don't think it strictly falls within the ambit or, within the scope of these 3 GBV acts. But it would definitely be something that the Department of Social Development can investigate, especially if the child is under the age of 18. So I think it would be a good idea to report this to the Department of Social Development as a child neglect issue.
okay, thank you.
Perfect. And then I see. Go ahead, Jackie.
No, that's fine. No, I think we were both trying to say that I see Francesca's hand.
Oh, yes. Go ahead, Francesca. We have 1 minute before we have to wrap up.
Thank you so much. Philip, if I understand correctly, the mother of the child was married to the guy, and the mother left her money to the child. The guy then married the girl when she was 18, but took her inheritance away from her and is not fulfilling his promises to her when he married her. I think that is gender-based violence. Not
Sorry?
only does I think it is gender-based violence, but it is also, there's also a lot of complex issues involved here. It's a whole load of criminality as far as I'm concerned.
Okay.
Okay, that's my opinion. Thanks.
So Philip, you have a lot to work with. If the two were married, and the child is over the age of 18, that would change the picture, and could possibly be domestic or financial abuse. If the child is under the age of 18, they're not married, it could be a child protection issue. So perhaps the Department of Domestic Violence, Department of Social Development might be a good starting point for you, because they would be able to assist you whether or not it's a domestic abuse or a child protection issue.
Okay.
Yeah, there may be other issues as well, depending on the circumstances. That could be, for example, theft, etc. Inheritance that a spouse receives normally is not regarded as part of a joint estate. So there may be other issues as well that can be looked into. Yeah.
Thanks, everyone. And thanks for that question, Philip. That was unexpected, but interesting. I want to, you'll see in the chat, Advocate Kambula posted the details of this afternoon's webinar, specifically about audio-visual linked testimony and the use of intermediaries. So it would be great if you could also join for that. The presentation of today will be sent to you by Luando. And so if you would like to type just your email into the chat, that would make that a lot easier. And I want to thank everyone for participating, and especially to Ms. Wessels for presenting and answering our questions. So yeah, we're going to keep the meeting open for another couple of minutes just to give people an opportunity to type in their email addresses if you want to receive the presentation. And yeah, thanks again for attending, and thank you, Yaki, for this really great opportunity with this webinar series. So yeah, we really are learning a lot. Thank you.
Thank you very much for moderating. Again, I really appreciate it. And for everybody else, for their assistance, and that includes Lwando. I had forwarded the presentation to him, so he would be able to send it through to anybody that's interested in getting hold of it. Like John had said, just put the contact, your email address in there, and Lwando would be able to send it through to you. Thank you very much. About this afternoon, yeah, we would like to just look at it a little bit more about so people can understand what kind of rights, for example, a witness have when it gets to coming to court, and maybe address a couple of the misconceptions about how they have to be at court, etc. So I hope to see some of you there as well. And thank you very, very much for everybody that has been involved with ensuring that we have this webinar series. And I suppose also just in general, if there are specific topics that people would like webinars on or specific aspects, please let us know, because we are going to continue with having webinars for, in particular, August with Women's Month, and then towards the rest of the year as well. Taking into account 16 days of activism is coming up as well. So we really would appreciate to also hear from everybody else about what specific aspects or topics they would like to have webinars on. I mean, sometimes, and this is why we were having this webinar today as well, there are a variety of issues that just nobody really seemed to be talking about too much, and we need to start talking about these issues and unpacking it, even if we don't have all the answers. So thank you very, very much, everybody. And I'm going to stand back now. John, you can have the last word.
Thank you. Yeah, Yaki, I'm just very concerned about your voice. There might be nothing left of it by the end of the day, and that would not be good. So you will just now keep quiet, and I will now say goodbye to everyone. If you want to hear more of Yaki's voice, you can join this afternoon. And in the meantime, please be safe. Please look after yourselves and others if you can. All right, everyone. Bye.
Thank you. Bye-bye.
See, you still have the last voice. You still have the last word, no matter what I do. Bye, everyone.
Later.